form of harassment or assault. This is a graph that was made by a journalist, I think. It's not an academic graph. It's sort of recounting how dense the Me Too movement was in the media. So each red dot on this graph represents a person who was accused of sexual misconduct in the news during that period of time. So you can see like the most allegations occurred in the fall of 2017, and they sort of dwindled over time, but they never went away. So this particular tally shows that 429, primarily men, were accused of various forms of assault or harassment since October 2017. Okay, so next I'm going to talk a little bit about what are the actual statistics around how common harassment is in the workplace in the United States. Oh, sure. And also, what is the law in the United States around harassment? Okay, so these are some statistics that were reported by the EEOC. The EEOC is the agency in the United States, the federal agency that is responsible for receiving harassment complaints, workplace harassment complaints in particular. These statistics, however, were not from the EEOC. The EEOC just compiled them from various academic sources for a report that they put together. So one of the challenges or problems with these statistics about how often harassment occurs is they're not actually based on the legal definition. So, for example, if you ask women, have you experienced sexual harassment at work? This would be this line right here. 25% of them say, yes, I have. But if you frame the question differently and you ask them, have you experienced unwanted sexual attention or sexual coercion? 40% of women say yes. So, you know, the way you ask the question is going to influence how people respond. And that's true also of these other types of surveys. Most of the research on harassment in terms of collecting nationally representative samples has been done by non-lawyers. And so they do not ask people the question in a way that matches the legal definition. And so they're really just asking people, you know, based on their personal experience, whether they think they have experienced this kind of conduct. So it's actually really hard to have a good empirical assessment of how common discrimination and harassment is from a legal standpoint. I think much of what people say they've experienced actually may not actually meet the legal standard. As I'll explain, the legal standard is very high. But in any event, if you ask people if they think they've experienced harassment, they believe it's quite common. You know, essentially half of people believe they've experienced a race-based harassment. A quarter of people who are older experience age-based harassment or disability harassment. Hi. The other interesting thing is that women are more likely to report that they've experienced gender-based harassment than various forms of sexual harassment. You know, the news and the Me Too movement focused very heavily on sexual harassment, like sexual conduct, unwanted sexual attention, sexual assault. But if you ask women about their experiences at work, they're more likely to report or describe gender-based harassment. So gender-based harassment would include sexual harassment, but it might also include comments that are like denigrating to women about about their role in the workplace. So, for example, a comment like, "Why are you here? You belong at home with your children," or "Women aren't good at this," or, you know, "Women, you're not tough enough to do this job," or whatever. Sexist comments in general. Those would be considered gender-based harassment. So even though sexual harassment has received the most attention in the news, if you ask women what they've experienced in the workplace, it's actually gender-based harassment is a more common experience for women.
Gender? Men.
Yeah, so men can also experience sexual harassment or gender-based harassment. So, you know, however, this particular LGBT is considered separate. I mean, not, but yes, but for this purpose, they were just asking women about their experiences as women. But under American law, men can experience gender-based harassment, men can experience sexual harassment, and LGBT harassment is kind of this related question that it has sort of ambiguous recognition under federal law. So LGBT harassment is also a feature of the American workplace as well. You can also, you know, if you want to be like really scientifically rigorous, you'll also notice that some of these statistics might be more reliable than others. So for example, a nationally representative sample, that's more useful for thinking about, is this really generalizable to the population? A convenience sample is, you know, just who the researcher was able to ask. That's not really as reliable. But so the gender-based harassment statistic and the sexual harassment statistics are more reliable because they're nationally representative. Okay. Any questions about this? Oh, okay. So the label is missing of this. All right. These are EEOC charges. So remember, I said the EEOC is the federal agency that's responsible for receiving harassment complaints. These are the types of complaints that they receive. So again, this might not really match what you might think is the statistics based on what we see in the news. In the statistics, sexual harassment gets all of the attention, but you know, race-based harassment is as frequent a legal claim as sexual harassment, and gender harassment is almost as common as sexual harassment in terms of the filings with the court. So this is an example of how, you know, popular attention to things may not actually match the underlying problems, and the gender-based harassment may be as big of a problem or more of a big problem than sexual harassment and race-based harassment. And of course, all of the other protected categories here, that would include things like religious harassment, or age-based harassment and disability harassment. This graph shows the frequency of harassment claims related to other types of employment harms. So harassment claims are somewhat common, but the more common claim that you see filed in the United States is a discrimination claim, usually in connection with being terminated from your employment on the basis of your gender, on the basis of your race, religion, age. A retaliation claim, that's like a whistleblower claim. So a retaliation claim is when, like, let's say you complain to your company that you have experienced harassment, and they do an investigation, and whatever, maybe they fix the problem, maybe they don't. But what happens to the worker after that is, let's say the worker is punished for having made a complaint because maybe the boss is really mad that they complained about harassment. And so the boss says, well, I'm annoyed that you decide to complain about harassment, so I'm going to like give you a demotion, or I'm not going to give you this promotion even though you're the most qualified person, or maybe I'm going to fire you because I'm angry that you made a harassment complaint. That would be considered a retaliation claim. So you can see those claims are actually quite common as well in the filings with the EEOC. Yes?
How is it possible for us to assess these numbers when probably the employers don't talk about the things?
Oh, well, that is maybe the most difficult question in all of employment law. So, yes, when you bring an employment claim, it's pretty uncommon to have, this is what we call, you know, smoking gun evidence. Is this a term you have in Brazil? Okay. Smoking gun evidence is basically an analogy to like a murder. So like, let's say like someone murders their neighbor, and so like the best evidence you could have that someone murdered their neighbor is the police arrive on the scene and the neighbor's holding the gun and the gun is still smoking. And you can say, obviously you killed this guy because you're holding the gun and the gun is still smoking. That's the best kind of evidence ever. So the best kind of evidence ever of a discrimination claim might be like that the employer says, I'm firing you because you're a woman. That would be smoking gun evidence. That would be a very easy case to win. But the American courts recognize that smoking gun evidence is not very common anymore. And so there's a bunch of evidentiary inferences that you can make. And essentially, workers present circumstantial evidence that the true motivation for the employer's decision was their race or their gender or their religion. So, for example, they might show that they were the best performing employee and the person who got promoted over them was a very terrible employee. Or they might bring other circumstantial evidence like the boss had made other sexist remarks in the past. Or maybe the company has a pattern of not promoting women over time when the statistics suggest that they are behaving in a way that is biased. So the American legal system has many different structures to use these different circumstances to help prove to a jury that the true reason the employer made its decision was because of the person's membership in a category like gender.
Jury decision?
Yeah, jury trial. Yeah, you can have, remember how we talked earlier, these cases never go to trial. But if you do decide to go all the way to trial, you get a jury. Mm-hmm. Okay, so what, here's some more statistics. Okay, one of the things that happened after the Me Too movement is everyone said, oh, Me Too is such a crisis. We're going to see a huge spike in litigation. Everyone's going to go to court over harassment. And that turned out not to be true. So you can see the difference between 2017 and 2018. There was like a little bit of an increase. It's a noticeable increase over the past, but it's not huge. It's like, 1,000 extra claims for the entire country. That's something, but it's not like a torrent, like a giant flood of litigation. Yeah, it's somewhat consistent with the historical trend. Note that this is sex-based harassment, so it includes gender harassment and also sexual harassment. It is a jump, but it's not that far off of the historical trend. And there's a few reasons for this. One is you can really only file an EEOC claim for harassment that has occurred somewhat recently. So the harassment has to have occurred at least in some point in the last year in order for you to file a claim. And one of the things we learned in the Me Too movement was that many of the complaints people were making about what happened to them were things that might have happened 5 years ago, 10 years ago. Those things are long past the statute of limitations, and those workers would have no ability to file a claim. And so I think that's one reason why you don't see these numbers reflected in the litigation, in the EEOC filings. By the way, if you want to file a lawsuit for harassment in federal court, you must file with the EEOC first. So even if the statute of limitations is 3 years, it doesn't really matter because if you don't file with the EEOC within a year, you have no claim. The other reason, which I will explain in a bit, is that the legal standard for proving harassment is very high. It's very, very difficult to prove a harassment claim because you have to show extremely bad conduct over a period of time in order to meet the legal standard. And the employer also has good affirmative defenses, even if you are able to prove that. So that's another reason why you aren't seeing a huge jump, is that if you have a sort of mild harassment claim, you'll have trouble finding a lawyer who's really excited to bring your claim because they know you might lose on a pleading early in the case. So remember, Me Too was, mostly attention about sexual harassment, but even here, we haven't seen a huge jump in filings. Yes, there was an increase from 2017 to 2018, but the 2018 number is like similar to the 2011 number. And this number goes up and down. And one of the things that's astonishing, this is for the entire United States, all of the United States, 7,000 claims. That's not a lot of, in absolute numbers, 7,000 claims is not a lot. Sure. Absolutely. Yeah, I think there's a lot of reasons why someone wouldn't want to file a claim. So I remember I was talking to a plaintiff's lawyer in Eugene, and he was talking about how he decides whether to take a case. And he told me that he doesn't really like to take cases from people who are still working at the employer who did something bad. So like if you have a harassment claim and you're still working there, he usually tells them like, don't file a claim, because he said it's better to have a job than a lawsuit. So he's just like, you know what, if you still have, if they've left and gone to a new employer, it's a little bit easier to file a lawsuit against your old employer. But, it's very stressful to be suing the person that you're still working for. Okay, so, that's supposed to say every crisis has many causes, but it's covered up. So this is the financial crisis. So you remember from the financial crisis when we thought about what caused the financial crisis in 2008, it was a lot of complex forces that led to this huge crisis. So likewise, when we think about Me Too, I think there are a number of different social and legal and frankly political causes for why we saw the Me Too movement explode in 2017. So I'm sure you can imagine what some of them might have been. Most notably, I think the election of President Trump is one reason why women were mobilized to act. So this is the Women's March from 2017. And it was one of the biggest marches in the United States. And I think it was people tend not to connect the Me Too movement to the Women's March, but it was an example of the way in which President Trump's election made women more activist and more willing to talk and more willing to take risks, because I think they felt like they were more under threat under the Trump presidency. And I actually think that is a strong cause for why we saw the Me Too movement. And of course, President Trump has himself been accused of assaults by several women and what we would call sexual misconduct. So, I think part of it is, maybe we didn't speak out enough about what President Trump did and he got elected. And so we shouldn't let that happen again, and we should speak out. I also think that was part of why we saw the Me Too movement. Another reason why we saw the Me Too movement is because of the legal standard, which left many claims unaddressed. So this is the Title VII of the Civil Rights Act. This is the federal law that prohibits discrimination, and it is the law that has been used to prohibit harassment. So Title VII of the Civil Rights Act says it's unlawful to refuse to hire someone or to terminate their employment or otherwise discriminate because of the person's race, color, religion, sex, or national origin. You can see that the word harassment does not appear in this statute. What happened was that the Supreme Court implied the word harassment in this statute through the words with respect to terms, conditions, or privileges of employment. And what the Supreme Court said was, if you harass somebody on the basis of their sex, for example, they can't really, you're changing the terms and conditions of their employment. They can't do their job. They can't succeed if when they try to go to work every day, they're faced with unrelenting harassment. And so the court said, harassing someone is equivalent to changing their pay or changing their title or changing their job responsibilities. It has a significant effect on these workers. And so we're going to give legal recognition to that kind of behavior as a change in the terms and conditions of employment. And so it was through that the court started to develop a legal standard and theory for recognizing harassment as a violation of the Civil Rights Act. Yes. You are full of difficult questions. Yes, so this is actually an issue that is coming back before the Supreme Court. So the lower courts at various times have disagreed about how it works. So there are sort of two aspects of gender identity that have come before the court. There's the LGBT workers, and sometimes those claims have had success in the lower courts as a form of associational discrimination, or treating similar people differently. So for example, you're discriminating against someone because of their relationships at home in a way that you're not discriminating against others, and that's associational discrimination, which we also recognize for other protected categories, but that doesn't always work. Actually, transgender workers have had more success under Title VII of the Civil Rights Act because that transgender workers fit more closely within a theory of law in the United States called sex stereotyping, where you punish workers who don't conform to gender norms. So there's a very famous case involving the accounting firm Price Waterhouse. You have Price Waterhouse here. So there was a very famous case in the United States involving Price Waterhouse, where there was a woman who was very successful at attracting and servicing clients at Price Waterhouse, but she was like a very hardened person. So she used a lot of coarse language, a lot of swearing, and she would sort of yell at people, but she brought in really big business. And when she was up for making partner, the other partners said, well, you know what? We don't really think you're electable because you're not feminine enough. So even though you're very successful at this job, you swear too much. We think maybe you should get your nails done and wear nicer jewelry, and maybe good luck to you. And what the court said was that's an impermissible form of gender discrimination because it's sex stereotyping, because you're punishing her for not conforming to your image of how a woman should behave. And if you look at her objectively, there are a lot of men that you promote to this position who use a lot of bad language, who are rude to people, but who bring in a lot of money, and those men you promoted. So you should promote this woman as well. So gender identity and transgender workers actually fare somewhat better under Title VII because it's easier to adapt their fact pattern to them being punished for not conforming to the gender stereotypes associated with their biological gender. So, but we do expect the Supreme Court to address this, and I think are mostly not optimistic that the conservative Supreme Court these days will recognize LGBT rights or gender identity rights. Okay, this is the legal standard for harassment. So I'm going to give you a special inside tip on how to do legal research in the United States. If you are ever uncertain about what the legal rule is in the United States, there's one really easy place that you can look, and that is jury instructions. Because jury instructions in the United States will condense whatever the complex law is into the elements of the claim, because they need to use those to explain that to a jury. So for a state law case, if you're looking it up, just go look for the jury instructions for that state. If you're looking up the federal instructions, go look up the instructions for that circuit. So there are no Supreme Court jury instructions, but there are jury instructions for each circuit. So California, for example, is in the Ninth Circuit. So if you want to know the elements of a claim in the Ninth Circuit, you download those jury instructions. It'll tell you the condensation of all the law in a very short form, like this one. So the elements of a harassment claim are that the plaintiff was subjected to unwelcome comments or conduct that was motivated by the person's membership in a protected category. Here's the various protected categories. These jury instructions are structured so that you will edit it. So if it's a religious discrimination case, you would just take out those other words and you would say the plaintiff was subjected to unwelcome comments or conduct based on the plaintiff's religion. Okay. And that the comments or conduct were sufficiently severe or pervasive that a reasonable person would find the work environment hostile or abusive. So this is actually the part of the harassment standard that is most difficult to meet, because you have to show that the harassment was severe or pervasive. So let me explain what severe or pervasive is with respect to Oregon weather, which I guess probably doesn't apply here, but I will help explain. Okay, severe conduct is extremely bad, like terrible, obviously bad conduct. Like, so the weather analogy would be like a lightning strike, right? This is sort of like catastrophic, obvious, extremely bad. So you can prove harassment based on extremely severe conduct, but that's not the only way. The other way you can show is pervasive conduct. Pervasive conduct is conduct that is sort of everywhere. It's permeating the legal environment. It's frequent. So pervasive in the Oregon weather version is fog. Do you have fog here? Maybe this isn't an Oregon thing. Fog is like not that much. Oh, okay. So Oregon, that's what all winter we have fog. You can't see anything. You can't see the house next to you because there's just fog everywhere. So pervasive conduct is like fog. It's just permeating the environment, it's contaminating the environment. Even though it's not really bad, if people are constantly making small, annoying comments to you about your gender, eventually that's going to get to you and make it hard to do your job. So the legal standard for harassment recognizes that if every day you go to work, you're constantly being bombarded by messages about your gender or your race, that is also a recognized form of harassment, even if there's no one single thing that happens at your work that is catastrophic. So you just have to show that it's severe or pervasive. Nevertheless, the courts still require you to prove a lot. So if you want to prove severe conduct, it has to be extremely bad. If you want to prove pervasive conduct, it has to be extremely frequent, or it can be a combination. But, in general, the case law developed in this area, in the early 1990s, it was mostly older white male judges, and those judges, generally tended to think that most of this conduct is not that bad. And so the case law over time forces plaintiffs to show like a very severe pattern of conduct to prove a legal claim. Okay, there's also a subjective component. So the particular worker has to show that they experience the conduct as very severe and hostile or abusive. So if you have like a employee who is, for example, very insensitive, and let's say this employee harasses all the other employees, and this employee is very coarse and is a very offensive person to begin with, that person will have trouble proving a harassment claim because they themselves don't seem as though they're offended by the conduct. So generally, you need to show somehow that like the plaintiff at the time believed that this was extremely problematic conduct. Any questions about that? Okay. Okay, so the other very strange peculiarity of American employment law is the standard for liability. So even if a plaintiff can meet all of these elements and prove up their claim, the employer still has various defenses, because the idea under American law is the harassing person is doing the harassment for their own benefit, not for the employer's benefit. And so the courts are reluctant to impose liability on the employer unless the employer was somehow complicit. Because the idea is that the harasser is only doing this for fun, and that it's not very fair to hold the employer liable for someone who's just doing something for fun or whatever. Not that I agree with this, but this is the American standard. And so you have these sort of complex rules around when the employer will be held liable for unlawful harassment. Okay. So if the harassment involved a change in the person's pay or termination, or there's a demotion, then the employer is strictly liable. So that's the easiest case. So if you were harassed and fired as part of the harassment, no problem. The employer is just liable if you can prove harassment. If that's not the case, it becomes very complicated. So there is a series of Supreme Court cases called the Farragher-Ellerth cases. Those are two separate cases that stand for the same thing. And they give the employer an affirmative defense in a few circumstances. Basically, if the employer took reasonable measures to prevent or address the harassment, and the employee failed to use those reasonable measures, then the employer can win the case. The employer has an affirmative defense. So, for example, let's say the employer provides a mechanism for workers to complain about harassment. They provide, like they say, hey, we want you to know we have a policy against harassment. If you experience harassment, please call HR. And let's say the employee doesn't call HR. They don't like HR. HR is not helpful. They don't tell HR. The employee cannot win their case. That's because the employer has an affirmative defense because it offered a mechanism to address the conduct that the worker did not use. However, this defense has also been used in other cases. So, for example, if the employee was a little bit slow in filing a complaint, maybe the employee waited 3 months or 6 months before they complained about the harassment. Even then, sometimes the courts say, well, you lose your case because that was unreasonable for you to wait to complain internally, and so you lose, and the affirmative defense applies. Doesn't matter if you have good reasons. They don't care. I mean, this defense has become extremely problematic. The other thing that you even see in cases, even though it's contrary to Supreme Court case law, is that even if the employee complained promptly, sometimes they still apply the Farragher-Eller defense if they think what the employer did was reasonable. So if the employee complains right away, the employer does an investigation and then does something, some nominal thing to address the harassment, sometimes even then the court will apply the Farragher-Eller defense, even though technically it should not apply. The other thing that empirical research has proven is that the courts do not really require very much in terms of employers to prove the defense. So generally, if you want to prove the defense, all you need to show is that you have a policy and that you made some attempt to investigate it. The court does not care whether you fire the harasser. The court does not care whether you made some effort to meaningfully discipline the harasser. They don't really care if you fix the problem. All they care about is that you can offer some story that you tried a little bit. And this has become a problem because you're basically rewarding employers for not trying very hard. And so they let the problem fester over time. And that's one of the reasons we saw in the Me Too movement.
This goes with something formal, I mean, a formal step-by-step procedure.
Mostly it's just, do you have a policy and have you made some effort to implement it?
You are supposed to prove that you have a policy, that this policy was explained to the employee.
Supposedly, but I mean, that's what the Supreme Court says you're supposed to do, but the lower courts are not really that demanding. As long as you have like a plausible story of that you tried a little bit, that tends to pass muster. So this is another reason why it's hard to file harassment complaints and why plaintiffs' lawyers are generally reluctant to take these cases. Okay. Also, there's a separate standard if the harasser is a coworker. If the harasser is a coworker, you have to show that the employer was negligent in the handling of the case. Any questions about that? Okay, this is, oh no, none of the text showed up. I think this is because I have a Mac on my, on the PowerPoint. Okay, so this is a scholar from UC Berkeley named Lauren Edelman. And Lauren Edelman is a famous sociologist. And she studied a lot of employment cases involving harassment and discrimination. And what she concluded is that that employer systems for resolving harassment and discrimination cases are what she calls symbolic compliance. Symbolic compliance means it's not actually that meaningful or useful or fixes the problem. It is just appears as though you fixed the problem. You have undertaken a policy to create the symbol for the courts to endorse that you have complied with the law. Yeah. So it's like, I don't know, buying a really expensive watch, like conspicuous consumption. It's not because the watch is really good or is the best watch or a good watch. The watch is for show, so other people will appreciate your watch. This is the same idea that all these employer systems for resolving harassment complaints, they're for show so that you can tell the court, look, we have done this nice job of fixing the problem, regardless of whether it actually fixes the problem. And she says the courts are complicit in symbolic compliance because they will rubber stamp these employer processes even when sometimes there's evidence that the process was extremely flawed.
Sort of requirement that this policy should be reviewed by external consultants.
You could do that. I mean, I think actually a better way of changing the employer processes would to make employers strictly liable. Because if they're strictly liable, they have an incentive to create a process that actually works to fix the problem because they are internalizing the risk and the cost associated with harassment. I think that would actually do a better job of fixing employer systems. Okay, so here's another, here's an ADR story about the Me Too movement and where it comes from. And that is that ADR contributed to the problem, and in particular, internal HR processes for handling harassment complaints. So this is a cartoon. Abandon hope. You have to go to human resources. Abandon hope, all ye who enter here. Okay, so here is a slide that shows employer systems for resolving harassment and also discrimination and retaliation complaints. What happens is the people who draft these harassment policies are not the people who use them. The people who draft them are people like me, outside lawyers, or the inside lawyers, or the human resources department. And these policies are full of what we call in the United States boilerplate. We have this term boilerplate in Brazil. Boilerplate. Boilerplate is like a colloquial term for like a standard legal form. So it's like a legal form, everyone uses it, they all borrow the same language, it's all the same. It's not meaningful, it's just like legalese, and everyone shares it and uses it over and over. You have such a thing? Yeah, it's just kind of standard practice. You know, like contracts, all like companies all use the same contract. If you go to a rental car company, they give you the same contract. It's all the same. We call this boilerplate. It's like McDonald's, like the McDonald's of contracts. Like all the policies are the same. You get an Egg McMuffin. Even you're working at the different company, they give you the Egg McMuffin policy, and you're like, why are you doing the same thing? Here's the problem with boilerplate, is it never changes. So somebody sometime in the past, in the 1980s, came up with a harassment policy, and then someone else started using it, and it sort of diffuses throughout the industry. And so one of the problems with harassment policies is they have this very old language. So there's a professor at Yale named Vicki Schultz who was studying these employer harassment policies. And she noticed that they had really old legal language. So the EEOC came up with the definition of harassment in the 1980s, which was before the Supreme Court ever recognized harassment as a legal claim. And this EEOC language shows up in all the harassment policies, even though it has no legal effect, and it predates actually the Supreme Court rule and the Supreme Court language, but you still see it. It's like the relic. It's like dinosaur bones. So these boilerplates, like they start out with like the dinosaurs are alive and then they die, and the dinosaurs are still in the contract, and they just sort of layer on like new pieces in the boilerplate, but it never fundamentally changes, right? So this is not a system that is adaptive to workers' needs. It changes over time. It's just this like really old, like 1980s McDonald's language with very slight tweaks when the Supreme Court comes out with new language. The purpose of the policy is also not necessarily to serve workers or to fix the problem. It's to help protect the employer from legal liability. And of course, as we already discussed, it's not very hard to be protected from legal liability. Okay. So the next stage in the McDonald's process of internal systems is they just give the policy to employees. They say, here's the policy, you sign it or whatever. And the policy has also become very regimented. So the policy never says, hey, if you have experienced harassment, here are some options for how you can address the problem. You could talk to your manager, you could talk to the harasser, you could talk to HR, you could talk to an ombudsperson, whatever. It doesn't ever give employees options for what to do. In that sense, it's worse than McDonald's, because at least McDonald's you can choose. It just says, if you have experienced harassment, you must report. And, perhaps this is true because to protect your legal rights, you actually must report, and you must report right away. And if you don't report right away, you have no legal claim. However, they don't give options. They just say you must report. And they also say to managers, you are required to report. If you learn about harassment, even if the employee asks you to keep it secret, or even if it's not big a deal, you must report. It is a requirement of your job. Everybody, you must report anytime you see harassment. And the policies also don't tell anyone what happens after you report it. They usually don't tell them how the investigation works, or what happens to people if they're disciplined at all for harassment. They just say you must report, and then your report goes in a black box. And that's not, the lack of transparency, I think, also erodes trust in the system. So the next step in the process, if you experience harassment, okay, you complain to HR. HR does an investigation. So the investigation might be, they'll talk to you, the victim. They'll talk to the person who's accused of harassment. Usually they'll talk to anybody else who witnessed it or who heard about it. Maybe they'll collect documents if there are relevant documents. Usually they do an okay job of investigating because they want to know what happened, because they want to assess what their legal liability is. So usually the actual investigation process is okay. And I think actually it would be better if they told employees how carefully they investigate so they would trust the system more. The real weakness and problem in the process is what happens after they investigate. Because at least before Me Too, companies had a very strong motivation to not do anything. So, it's like the Mueller report, like, oh, the Mueller report, look at all these bad systematic problems we identified. Thank you very much. We're going to do nothing. Right. So this is also what happened in the, in HR is they'll say, thank you very much. But, oftentimes the person who was accused of harassment, in many cases, they might be a very powerful employee, or they might be an employee that the company perceives to be valuable and useful to the company that the company is reluctant to fire because maybe this employee is responsible for a lot of sales accounts, or maybe this employee is really good at computer coding. And to the company, it feels like it would be very expensive to get rid of the person who is engaged in harassment. So even if they finish the investigation and they determine that the harassment occurred, usually what they will say is, well, this harassment, it didn't really violate the policy. Or they'll say it violated the policy, but it wasn't that bad. Because actually the policies tend to be pretty broad. So it's pretty easy to say it violated the policy. But in general, there's a big gap between what the policy requires, because the policy usually says everything is prohibited. But as we know, the legal standard is very hard to prove. So they'll not, it violated the policy, but everybody knows it's not a violation of the legal standard. And so everybody knows that if there was a lawsuit, the employee would probably lose. And so the employer knows this is not really a good legal claim, so the employer does nothing. And so they say, oh, well, I think what we'll do is we'll just give this employee a reprimand. That was one thing they'll do. Oh, so we'll put a note in their file that they did this and that what they did was bad. Or they might say, you know what? I think this employee who harassed other people is very misguided. And what they really need is more training about how not to be a harassing boss. And then they'll hire an expert coach who will sit down with the harasser and say, harassment is really bad. You shouldn't do it anymore. Like your behavior, like other people find it offensive. Like you should try not to be an offensive person. So this was like before Me Too. This was the standard response is you would have these sort of fake disciplinary measures. So the person would keep their job, keep their pay, keep their position, but you put a note in their file or to give them extra training. Right. And then what happens at the end is the victim is only told the investigation is over. They're not told whether the person was disciplined, probably because they weren't. But even if they were, HR would refuse to tell them. HR would say like, well, we can't tell you what we did with the perpetrator because that violates their privacy. See, again, so it's as a legal matter, it does not violate their privacy. There is no legal rule that says you can't tell someone that someone else is disciplined. This does not exist. But, like I said, like the American system is obsessed with privacy and obsessed with confidentiality. And so are these strong norms around protecting the privacy of the harasser. And so they have these norms of like, even if the employer happened to demote the person or cut their pay or warn them, if you do this again, you're fired, you would never tell the victim that. You would just tell the victim, well, we want you to know that the investigation is over and that there was a policy violation, and they wouldn't tell you anything else. So you could imagine that this system of prioritizing the privacy of the harasser over everything else might erode trust in the system. And even if you had a system where the employer was being actually very strict with harassment, you can imagine employees would say, this employer is doing nothing. I don't trust the system. I'm not going to use these complaints. This problem is just going to fester. Maybe I'll quit my job. And so you can see how like the continual problem of harassment in the company wouldn't be addressed. And then you would also have sort of a growing pile of victims who are not happy with the way their problem was addressed and who are disgruntled and sort of later motivated to talk about it on social media or talk to a journalist about it. Questions? Yes. No, that's not really part of the typical process. I think it depends on what the victim wants. So if what the victim wants is to sit down and explain to the harasser why what they did was wrong and explain to them the impact they had on them, I think that should be an option. I don't think victims should be forced to do mediation, but if they want to do that, I think that's okay. But it's not we're currently not an option in the system that employers develop. Yeah, you could have a restorative process. Sure.
Also, I have two questions. What is it, the role of unions? Unions worried about this?
Oh gosh. Okay. So unions have a different dispute system, right? So remember how we talked about labor dispute resolution processes are different. And actually, it became extremely problematic in the unionized setting as well. And here is why. Because the union represents both the employee who is the victim, but the union probably also represents the harasser. And also, unions in the United States tend to be very male dominated. So what you would have is these systems where a victim might complain about harassment, the employer investigates, and the employer might say, well, we find that, the harassment was warranted and we want to discipline this harasser. Who does the union represent in this dispute? The harasser. So unions were commonly in the position of arguing with the employer that the harassment wasn't that bad, that it was undeserved, that this is like a violation of due process, that the harassment doesn't qualify as cause. And so unions in the United States have actually been complicit in this problem because they find themselves primarily in the role of representing the harasser and not necessarily improving the system or providing better accountability when these problems arise. Yeah.
NGOs.
Yeah, so I mean, I think right now unions are starting to have a bit of a crisis of thinking of what their role is and how can they address it. I mean, part of it is that unions have a duty of fair representation, and so they view their duty of fair representation as protecting the person accused of misconduct, even if that misconduct is harassment. But it's a big problem.
Do you try to interfere with the compliance process and the compliance system? Try to push the compliance system to be more open,
The unions?
fair.
I mean, no, because largely in American unions, their role is to protect employees from discipline. So this is like contrary to their interests. So it's like another systemic force that would lead to like the Me Too system. And in fact, in the United States, we've seen a lot of blue collar female workers complaining about sort of systemic harassment over the course of many years that the union failed to address. Yes. At the end of the investigation. Well, I think the first thing they should do is tell the victim what the results were. I think that would make a difference. I think even if the victim doesn't agree, I think that it helps the process to feel like the victim was treated honestly and fairly. So this is sort of the idea of procedural justice. I think that would make a difference. I think it helps to ask the victim, what do you think would be a good outcome? And sometimes employers don't even ask that or take that into account. And it may be that the victim doesn't want the person to be fired. The victim wants, a chance to explain what they did wrong, or maybe wants the person to have like a pay cut or something, or a demotion or something. I mean, but I think it would be better to have a more consultative process. But also I think it would be better to give workers more options about what to do, because it's true that almost all of these cases are not legally harassment, and the employer probably isn't going to do anything in a result. And so if the workers know that this process is not going to end in an extreme discipline, maybe they don't want to go through it. So if you're honest with workers on the front end about what harassment really is, then you can give them more options about how they want to deal with it. And maybe if they know that this is kind of considered a minor type of harassment, maybe the worker would prefer to just sit down and have a conversation with the harasser, or have a mediation, or have, abbreviated process, or have somebody else talk to the harasser. But like, I do think that most of what this system suffers from is a lack of transparency, so that the affected workers can make informed choices about what procedure they want to use. Okay, so here I talk a little bit about, this is sort of similar to the whole conversation this week. What are the systemic factors that are leading to the process weaknesses here? Okay, so as I described earlier, one of the problems with this process is it doesn't give employees options other than just report or not report. The other systemic weakness that we see in these policies is they only cover employees. And we have a big problem in the United States of, independent contractors. There are many independent contractors in the United States. These employees are not covered at all by the legal protections. And because they're not covered at all by the law, the policy doesn't cover them. So if you're an independent contractor that has been harassed, you have no protection. Under the law, nowhere, no, you have nothing. And so the policies don't cover them either.
So the first step would be in order to prove the mistake and the misclassification.
Yes, if you're misclassified, then you're protected. Yeah, so
You
that
have
would
to
be the
prove-
first step. You have to prove your employee, and then once you prove your employee, then you can prove that it was a harassment claim. But if you're properly classified as an independent contractor, you have no recourse. Right, and because the system suffers from a lack of transparency, the employees get most of their information from other employees. And so well, nothing was done. All we know is there was a harassment investigation and that guy's still working there and he still has a job, so probably nothing was done. And so most of the reputation of the system becomes very problematic because the employer is not sharing the information. And then, of course, employees don't trust the system and they don't use it, so the harassment continues unaddressed because the employer doesn't even have a chance to investigate it. These weaknesses in the way the policy is designed are in part caused by weaknesses in the legal system, right? So because we have that Farragher-Ellerth defense that allows employers to get off the hook for doing almost nothing, that's why they design these processes that do almost nothing. Because the law doesn't require them to do more than nothing, more than a little bit, right? Because the law does not protect independent contractors, employers don't protect them in their policies. Because because the rules do not require employers to disclose their processes or disclose the results of their investigation. Employers don't feel like disclosing it, they don't disclose it. So you can trace back some of these process weaknesses back to weaknesses and loopholes in the legal system. Should we take a break? Yeah, let's take a break.
Short break.
Yeah. Okay, let's take a short break.
Ready?
Yeah, I'm ready. Okay. Hello.
People. Hello.
Okay, so this is this sort of second part of the process that I was describing earlier. And we already talked about some of these process weaknesses associated with the way that employers resolve these complaints. So, you know, the employer will tell the victim to keep all of the information about the investigation secret. And they have a okay business reason for this, which is, you know, sort of like in courts where they tell the witnesses not to talk to each other. You don't necessarily want to contaminate somebody else's testimony by telling them your story or influence their testimony in any way. So they want to preserve the investigation by having the witnesses not talk to each other.
Please, excuse me, just to interrupt. At this point, the complaint is a formal, it's a written complaint. It's supposed to keep the proof that you filed the complaint.
No, it's, you know, American things are very informal. So maybe you complain to HR by sending them an email saying, hi, I want to talk about something, and you go and talk to them. Or maybe you call them and say, I want you to know that I was harassed, or whatever. I mean, it's a very informal channel, which, you know, the company is very happy that you do not have strong records of your complaints. So there's not a strong incentive for the company to say, well, it is very important for you to keep records of all of the time you were harassed. And actually, this is actually interesting. So one of the studies that I did was on harassment trainings. In the United States, there is a big industry of harassment training programs where specialists will come in and they will train all of the workers at your company on how to complain about harassment and address harassment. And then they tell workers, here are all of the things that are harassing and you should not do that, and that is bad. So one of the things I did was I looked at old harassment trainings to see how they've changed over time, because I had a suspicion that the trainings were also a kind of boilerplate, sort of like how the policies are boilerplate. I had a suspicion that the trainings were boilerplate. So I was curious to see what the early boilerplate looks like. And so I found all of these old trainings in the library that I watched. And some of them were very similar to the ones now. You could definitely see the boilerplate. But there was also things that were different in the very earliest trainings from the, there were a few trainings from the 1980s and the early 1990s, before the training industry became mature and before trainers realized what is the best way to sell their training to a company. And so in the very earliest trainings, sometimes they would give advice to the workers. And you never see this anymore. But in the earliest trainings, they would be like, if you have been harassed, keep documentation of every time you were harassed. And then they would show footage of someone, you know, writing on a piece of paper, today I was harassed by so-and-so. And then they're supposed to fold it up and put the date on it and fold it up and put it on their bookshelf to preserve as evidence for later. This you never see anymore, because people who provide these trainings know that their client is the business. Mm-hmm. And the business doesn't want you to keep records of all the time you were harassed. So that has also completely disappeared. Mm-hmm. The other thing you would see in these early trainings is they would say, if you have been harassed, you can call the government agency and they will help you. You should call a lawyer and a lawyer will help you. That also totally disappeared. They don't want you to know that this is a legal claim for which you might call a lawyer. So in the current trainings, they never mention lawyers, not ever, or only government agencies if they're required to disclose it. Okay, so anyways, they tell the employees you should keep your complaint secret because they don't want to contaminate other people's evidence. And this is true, but they also have another great reason for telling you to keep it secret, which is they don't want you to talk about what happened to you. They don't want you to put on social media, I was harassed, this company is terrible. They don't want you to tell other workers, I was harassed, that boss is horrible, he's harassing everyone. They don't want you to do that. So it's very convenient for them to say, well, do not talk to anyone to preserve the integrity of this investigation. Actually, they just don't want you to talk to anyone, period. So they say it's very important to keep it secret, blah, blah. They don't really discipline, again, because the legal rules do not require them to. And then, of course, it's a system that perpetuates itself where people don't use the system because they think nothing was done and they talk among themselves and trust in the system erodes. And of course, there's no downside for a company if the employees don't use their system. In fact, the employer benefits if employees don't want to use their system because then they have no legal claim. Okay, so this is my sort of diagram of what's happening here, which is that you have this sort of crumbling legal rules that are extremely problematic, and it is these crumbling legal rules that are propping up this problematic dispute systems design and contributing to the problematic dispute systems design. And this problematic dispute system then creates a groundswell of unresolved disputes and discontent from employees about the way their harassment claim was treated. So how should we handle this problem? So this is actually, don't treat this as scientific, because this is just that, remember that diagram I showed at the start that a journalist made about all the claims against men during Me Too? I just turned it upside down. That's why it's upside down. This is not at all scientific. And then I made a box, and I'm saying these claims, this arbitrary box of claims, let's just assume this box of claims represents the subset of cases that have a valid legal case. So let's just assume, for the purposes of discussion, that this many cases are ones where you might actually win at court. What happens to those cases where they complain to their employer does nothing, they're very unsatisfied, and they have a good legal case? What happens to those under our current system? Oh no, okay. What this slide was supposed to say was, what do we do when our ADR system creates all of these unresolved claims? More ADR. So the American analogy to this is a pie eating contest. You have pie eating contests in Brazil? Maybe not. It's a strange tradition. It doesn't make any sense. I do not recommend it. The Americans have this silly culture where they have state fairs, state fairs with a lot of rides and a lot of food and a lot of games. And one of the American traditions is something called a pie eating contest, where grown-ups or children have a contest to see how much pie they can eat before they, basically feel sick. And whoever eats the most pie wins the pie eating contest. And so, so one of the jokes we have in the legal profession is that it is like a pie eating contest where the prize for winning the pie eating contest is more pie. Right? So, so in the American law firms, if you're very good at being a lawyer and the law firm really likes you, what's the prize? More work, right? So it's a pie eating contest where the prize is more pie. Same thing. It's like the ADR. The ADR process has all of these problems. What is the solution to that? More ADR. It's like, obviously that's not going to fix the problem. But that is what actually has happened in the United States, and I will explain why. So what do you do with all these legal claims, these valid legal claims that are left over from this bad ADR process? Well, actually, they're resolved through ADR, because maybe these people hire a lawyer and they bring a claim, but how are those claims resolved? Almost all of them go to ADR. And the thing that became very problematic in the US system is these cases were resolved by ADR, and the employer would demand that the worker keep everything secret. And so you had this sort of groundswell of people that were unhappy, who settled their claims and were required under the terms of the employer's contract to keep that settlement secret, and so that no one would know. Okay, so I'm going to show you some excerpts from a settlement agreement involving a celebrity named Bill O'Reilly. This is probably not someone you've heard of, Bill O'Reilly, and that is a good thing that you've never heard of Bill O'Reilly. The United States has a very popular news channel called Fox News. Have you heard of Fox News? Yes. Okay. So Bill O'Reilly was a very popular personality on Fox News. And he would stand up there every day on his show, and he would just say all these, extremely right-wing things. And he got paid a lot of money. But what people didn't know until a few years ago is that Bill O'Reilly was a very bad serial harasser. And he would harass like various women in the workplace. But the reason people didn't know is that he would just settle these claims, and Fox would settle these claims for a lot of money. And so he'd just do this over and over, and he would just created this pileup of legal claims until eventually some of the women started to speak publicly. And it became clear that Fox had spent millions of dollars settling Bill O'Reilly's harassment claims, and they eventually got sick of him and fired him, which also was highly unusual at Fox. So Bill O'Reilly's settlement claims also had an arbitration provision, which is another reason why they were able to keep it secret and not file it publicly. But there were disputes in the court about whether those cases had to go to arbitration. So there subsequently came to be some litigation filings. And recently, like last year, the judge refused to seal the copy of Bill O'Reilly's settlement agreement. So for the first time, we actually have copies of these settlement agreements. And the most interesting thing is all the crazy, insane secrecy provisions in Bill O'Reilly's settlement agreements. So I'm going to show you some of these extreme confidentiality provisions, which, you know, this is not typical, but it's an extreme version of the way that employers like to handle secrecy when they're dealing with harassment claims. Okay, so this is actually kind of a typical confidentiality claim, and provision, and you don't need to read it. So it basically says, the parties agree that the nature and terms of the settlement are confidential, including the existence of the agreement, right? So you can't tell anybody how much you settled for. You can't tell anyone what's in the contract. And if you're the victim, you cannot even say that you entered into a settlement contract. You can say nothing. The existence of the contract is secret. The existence of the agreement is secret. Yes. So I'm not really sure, like, if someone asks you if you entered into a settlement, I guess you would just say nothing, or I don't know. The whole thing is secret. Okay. That's actually pretty common provision. The terms and existence of the contract are secret. Okay. Then they said, well, you may not make, this is a little unusual, you may not make any statement except for this press release, which we're attaching it as Exhibit A. So you can only make this one statement, which we're agreeing that you're allowed to say, and you're not allowed to say anything else. So here is the statement that they're allowed to make. So I would like you to read this statement and then talk with your neighbors about what you think about this joint statement that they're required to say. Ms. Macris is the plaintiff. Of course, Ms. Macris is the counsel. Morelli and Associates are Ms. Macris's, the victim's lawyer. So please talk in groups about what you think of this statement the parties are required to make.
Why they search for this ongoing court?
Yeah, I know, I understand the question. It's complicated. I mean, basically,
we have also a lawyer. So why they elect?
yeah, no, I understand the question. It's a difficult question to answer. I think it's different in each case. I think they probably knew that if they continued to litigate or arbitrate, that Bill O'Reilly would continue to say horrible things about them in public for years and years, or however long the litigation went on. So one of the really strange things about this statement is it says, we withdraw any assertion that any extortion by the plaintiff occurred, right? So Bill O'Reilly was out there saying that, you know, he was prepared to say none of this is true and this is extortion, and that they are trying to blackmail me. So, you know, I think they were reluctant to have their reputation completely dragged down air every day for Bill O'Reilly if it ever became public. But of course, this statement is also really strange because Bill O'Reilly planned to say it in public. And so, I mean, what do you think is the meaning when you go on TV and you say, well, we all agree that no extortion occurred? Right, right. So it's kind of ridiculous to say we agree that nothing happened, but we're settling to say that nothing happened. I mean, what does that mean? And it's sort of the same. We agree that no extortion happened. Is that suggesting that maybe there was extortion, but now you agree it wasn't extortion? I mean, one of the strange things about this statement is it suggests that someone thinks there's extortion, and that's actually kind of problematic too. I mean, I think the other thing is, you know, these settlements were for a lot of money, and maybe more than they would ever expect, to receive in court. This one I think may have started in arbitration. I don't remember. It later ended up in court, but I think it might have started in arbitration. I don't remember. But I mean, the settlement was for millions of dollars. Yes. Now, of course, he didn't file a criminal complaint. It wasn't extortion, but Bill O'Reilly enjoyed saying he was being extorted because it's a way of saying none of it's true and it's all fabricated. Yes, it of course is criminal. Yes. Yes. Okay. Mm-hmm. 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 Yeah. Mm. Mm-hmm. Mm. I see. I mean, the other thing that I find objectionable about this Exhibit A is it suggests that, like, you know, everyone had contributed to the problem, sort of like we were talking to yesterday. So this isn't really about Bill O'Reilly being abusive and harassing. This is about everybody caused each other tremendous pain. And because everyone is in pain, including Bill O'Reilly, they have agreed to settle, right? As though, like, you know, the victim is equally responsible for the fact that Bill O'Reilly engaged in this course of conduct. You know, and everyone agrees, obviously, as you said, everyone agrees that there was no wrongdoing, even though obviously if you're engaged in the settlement, there probably was something that happened. Any other thoughts?
Well, would you go to discussing groups?
They don't seem that enthusiastic about discussing
No,
it in groups, so we don't have to. They don't seem enthusiastic. It's okay.
But,
Did you have something?
yes.
Okay, go ahead.
Just to shred. Look at this. Out of respect for their families and privacy. So this is the reason why they bring us fundamental of this so hard commitment with reality.
Mm-hmm. Yeah. You know, again, it suggests that, you know, the true victim of this is Bill O'Reilly's family, which I'm sure this is not fun for Bill O'Reilly's family. But again, it takes away attention from what Bill O'Reilly decided to do, and that who's responsible for this. Okay, here's the next provision, which this is actually the most. Oh, this is not. This is the second worst. This is the second worst provision. This provision basically says, and we actually saw some of this similar language in other Me Too abusive cases where they basically are telling the plaintiff she has to return all evidence. So in the American system, a lot of evidence is turned over in the course of discovery. So the defendant has to give a lot of documents over to the plaintiff. And this provision says you have to return it all to Bill O'Reilly, presumably for it to be destroyed. So part of the way these settlements are structured is give back all of the evidence so it can be destroyed, so that if anything ever comes up again, there is no evidence that it occurred, right? So part of the purpose of this function is to force them to return any evidence that it happened for any later dispute in the public or otherwise. Mm-hmm. There's no judge involved in this at all. Judges do not need to approve these agreements. So typically, well, if it's not filed in a court, obviously there's no judge involved. If it is filed in a court, typically the judge is not involved either. What will happen is the parties will agree to a settlement. The settlement will be secret. And then one party, the plaintiff, will file a notice of dismissal. And so the judge may not even know why the case was dismissed or what the terms of the settlement are. The case just disappears from the docket. But at least in cases where it's filed publicly, there's some record the case occurred. But if it never reaches the court, then that doesn't happen. Or if it's an arbitration, it would be extremely difficult to find, if impossible to find. So yeah, the judges are, for the most part, not involved. Oh, yes. Okay, yes. I'm having trouble remembering, but I think what happened was Bill O'Reilly filed a defamation claim against the woman. Or she might have filed a defamation claim against him because the settlements were supposed to be secret and they weren't supposed to say anything bad about each other. But even so, I guess Bill O'Reilly started talking about it on his show and started saying all of these things that were factually wrong. So I think what happened is the women filed a case for defamation because Bill O'Reilly violated the secrecy provision, or it might have been the other way around, but they both had claims against each other for defamation, and that's how it ended up in court. And so these secrecy agreements were actually critical to the resolution of the defamation claims. And so the court decided to refuse Bill O'Reilly's request for them to be secret, because the parties in the subsequent case of defamation, the parties were attaching this agreement to their pleadings and saying that these pleadings should be under seal. And the court reviewed and said, no, they're not under seal. Anyone can look at them. Yeah, it's kind of crazy. It is true that victims sometimes use these confidentiality provisions to their benefit to later say, you breached your contract because you, the perpetrator, are the ones that's talking about it, and you agreed for it to be secret. So, you know, these secrecy provisions don't always work against the person who's been victimized. Sometimes they prefer for it to be secret, and then they're upset when the harasser won't stop talking about it. Okay, so this is the sort of turnover materials, destruction of evidence provision. Okay, this one is actually, to me, the craziest one, and I've actually never seen this particular provision before in an employment-related claim, and I'll explain the significance of it. So the Morelli firm, as you recall, represents the plaintiff, represents the victim in this case. The crazy thing about this provision is they're agreeing to provide representation to Fox News, to the other side of the dispute. Why would they ever agree to do that? And why would Fox News want legal advice from the plaintiff's lawyer? Does anyone have a guess for why that might be? Yes, you got it. So the intention of this provision is to create a conflict of interest that will prevent the plaintiff's lawyers from ever representing anybody else in any lawsuit against Fox News. Right? So this is like essentially a strategy so that the law firm will stop suing Fox News into the future and won't represent any other victims. So you can see that this provision is questionable because there's this section near the end that says, if this is a violation of the rules of professional conduct, blah, blah, blah. You always know it's a problem if you ever see a contract that says, if this is a violation of the rules of professional conduct, blah, blah, blah. I mean, that's a sign that you might be doing something that's a little bit unethical, right? So this is very strange. Sometimes you see these in class actions. I mean, it's smart. I mean, why did the plaintiff's firm agree to this? I don't even know. I mean, I think it's problematic that the plaintiff's law firm would enter into an agreement like that. Okay, so what we actually saw during the Me Too movement was that Me Too disrupted this cycle, disrupted the cycle of ADR systems not providing good service to people who are affected, and then ADR then making everything secret after a dispute arises from these problems that weren't resolved internally. So again, here we're at this fake graph. Don't read too much into the fake graph. This is supposed to represent so the people outside of the box, these are all people who are not subject to a confidentiality provision because they never settled the case. They're allowed to talk under the National Labor Relations Act. They're protected for posts on social media. So Me Too produced like this whole groundswell of people who were unhappy with the way their harassment complaints were resolved. And these people who are outside of the box, they're all able to speak. They're legally able to post on social media. There's nothing stopping them from doing that. So of course, in Me Too, these people did say, you know, I was harassed. And there was just this groundswell of people saying I was harassed. Then there was this subset of people who might have had a legal claim. And these people were subject to, most likely were subject to confidentiality provisions. But what we saw in the Me Too movement was these people started saying, you know what, I don't care about the confidentiality provisions. I don't care about the secret settlement. It's important to talk. I'm going to talk publicly and I'm going to break the confidentiality provision. So Harvey Weinstein, who was at the center of Me Too, was the most aggressive about obtaining extremely secret settlements and using all sorts of strange contract provisions to prevent people from talking. And it was Harvey Weinstein's victims who decided, you know what, I'm going to talk anyways. I might have to give back the money I received, but I don't care because this is important for the public. And it was those people who were willing to speak to the journalists and who sort of broke the story. Yes. Mm-hmm. Well, again, this graph is not really meaningful. I mean, I think this graph is a bunch of different things. I think the fact that it decreased over time was like the really bad actors in journalism, in media, in Hollywood were revealed early on in the stage. And I think there was just fewer of like the really famous people the journalists wanted to cover who were accused of harassment. So part of this is just a story of like media attention dying down. Now, of course, there may be others who also engage in harassment who aren't as famous, but journalists might be tired of writing the story. I mean, we've heard the Me Too story. People don't want to read yet another person who engaged in harassment. So part of this is just media attention and maybe, you know, finding the big fish early on and not being as many good stories later on. But of course, the Me Too hashtag has been used millions of times, you know, by involving regular people who aren't accusing people who are famous. These dots are only really famous people who are accused. Yes. Mm-hmm. 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 Yeah. Yeah. So, I mean, I think Me Too reflects, you know, the broken system because, I mean, I think for the most part, the women who are speaking out, like that's not their preferred form of resolution, right? They probably would have preferred to just give the complaint internally and have it resolved internally. And, or maybe they would have preferred to go through the legal route and maybe they're okay with confidentiality. So I don't think in general, social media is people's first choice for resolving their harassment complaints. And I don't think people think that social media is the best way to address harassment going forward. I think maybe what everybody wants is for employment systems to be better, where everyone respects the process and they're happy to abide by the result, and that you don't have this sort of groundswell of discontent where the cases are being litigated in the public, where that may not be anybody's first choice is to litigate them in public. Yeah.
Less than of the sexual complaints are the false or
Mm-hmm.
false
Mm-hmm.
similar
Mm-hmm.
in the US.
Mm-hmm.
Most cases are true cases.
Yeah. I mean, the disputes I saw, you know, in my work were mostly cases where everyone's more or less agreed about what had happened. You know, and generally people in many cases were truthful about what had happened. And the dispute was typically around the meaning of the conduct. So, you know, the man would say, or it wasn't always a man, but, you know, whoever engaged in the harassment of any variety, not just gender-based harassment, would say, oh, yes, I did this thing. But, you know, it wasn't a big deal, right? It's very common for the harassers to minimize what they did. So I wasn't actually harassment. It wasn't a big deal. They misunderstood what I meant by it, you know, and they would try and minimize what they did. And the employer had a strong incentive to go along with that because it was easier for them to say, well, it's not a legal violation, it's just a policy violation. And so, you know, most of the disputes I observed were not around whether the conduct occurred, but how we should understand the meaning of what it was that occurred. Yes. Yeah. Yes. So typically the remedy when you breach a confidentiality provision, typically the remedy is for the contract to be unwound. And so what would happen is if you breach the contract, the court will treat it as though the contract didn't exist or as though the parties didn't perform it. And so like theoretically, the idea was if you breach the contract to such a large degree, you would have to give back the money that you received. Sometimes these contracts, or especially the most abusive contracts, would have a liquidated damages provision. So liquidated damages will say, if you breach the confidentiality provision, that's considered a material breach and you need to give X dollars. And we apportion X dollars to it regardless of just as a deterrent to talk. But what we saw during the Me Too movement, and also, you know, breaching a confidentiality provision, this is not a new idea. So there's actually a fair body of case law in the United States for how to handle it. And you would see cases on both sides in various types of cases where one person wants to talk and the other one doesn't. So my favorite case actually involved this psychic and a journalist. And so the psychic had a very good business model where the psychic would say, I will predict the future, you will love me. And they had this nice client base for predicting the future. And then there was this journalist who would say, the psychic is terrible, they don't know anything, like you shouldn't use the psychic's business. And so they were constantly involved in these fights where one of them would sue the other one for defamation, for saying bad things about them. And they were constantly stuck in the court system fighting over whether the psychic's opinion was true. And so what would inevitably happen is they would enter into a settlement agreement where they would both agree, okay, we promise this is over. We settle our disputes against each other. We're not going to sue each other anymore, and we're not going to talk about it. You know, there is a case where confidentiality makes sense. You want the dispute to be over. Stop misusing the court's resources over whether being a psychic is true. Let's go on with our lives. Right? So there was a lot of litigation around that. What happened, though, was that both of them kept breaching the confidentiality provision. So they kept going back to court like over a decade over who had breached the confidentiality provision first. But you can see why courts feel like, you know, courts are okay with these settlement agreements. Courts are okay with confidentiality because confidentiality is one of the ways for the dispute to be over forever and to not come back to the court. So you could see why there became a legal culture of people being okay with secrecy. It was part of the idea of finality. But what happened during Me Too when people broke confidentiality provisions was you did not really see enforcement by the companies who were affected because they realized that the publicity associated with trying to get a victim to stop talking would be much worse than just doing nothing. So for the most part, there really hasn't been any follow-on litigation from the breach of these confidentiality provisions, with the exception of Bill O'Reilly, I guess. Okay, so the big change that Me Too made in the United States was it increased the business cost of harassment. The legal landscape has not changed at all in the United States. But what has happened is the companies realized that it is very problematic for their business for accusations to come out, especially against one of their high-profile employees, or for many employees of the company to complain about harassment at once, which suggests that the company might have a toxic culture. So this is one example of a business being affected by Me Too. This is the stock for CBS Corporation. That's a television company, media company in the United States. And its chairman and CEO, Les Moonves, was accused by a number of employees of harassment in an article in a magazine called The New Yorker. And you can see the stock price dropped by quite a bit right after, I think actually, if you look at it started actually dropping once there were rumors that there might be an article in the New Yorker. It was already on its way down based on rumors alone. But the moment that article came out, the stock took a big dive. And so what you're actually seeing now is companies are changing their internal dispute systems and their approach for disciplining people accused of harassment because they're worried about the business costs and the reputational costs of harassment.
It was August 27th.
Might have been, I think, August 8, 2018, actually.
18.
Yeah. So, you know, those of us in the legal academy, when we're talking about how to fix a problem, we're always saying, well, you should change the law, fix the law, and I still say that. But this is an interesting example where, like, the social movement actually changed the problem, and the social movement put pressure on dispute systems design to change the way the systems are implemented and operated. Okay, so this is actually how, like, the systems are primarily the same, although I think companies are revisiting their policies a little bit. But what has happened now that's different is that where companies conduct an investigation and decide that harassment has occurred, they're more likely to fire the person who engaged in the misconduct rather than doing nothing, because I think they are aware that, you know, if it becomes public, if the victim decides to go on social media, it will be embarrassing for them if, you know, it later shows that they didn't do anything. So they're being more aggressive about enforcing their own policies and responding seriously. We have not really seen a legislative response at the federal level. Congress has not really changed the laws around harassment.
No proposals?
I mean, sometimes there are proposals, but mostly they relate to arbitration. They not really in terms of changing Title VII. You haven't seen anything like that. States have responded by attempting to regulate confidentiality agreements. But it actually turns out to be extremely difficult to regulate confidentiality agreements in an efficient way that achieves the goals of the legislation. And I'll explain that in a minute, but first I want to see if there are any questions about what I just covered. Okay, this is why it's really, really difficult to regulate confidentiality agreements. Employers have legitimate reasons for wanting to have a confidentiality provision in their contracts with workers and in settlements. So, you know, when workers in the United States start their jobs, they typically agree that they'll keep all of the company's confidential information secret. And that is intended to protect their trade secrets from competitors. And that's a legitimate use. And they often define confidentiality very broadly to cover all sorts of business information. And one of the problems is sometimes that broad definition might include things like harassment or misconduct. They also have other reasons why a settlement agreement might want to contain confidentiality. So protect the privacy of everybody involved, to have peace at the end of the dispute, like we talked about with the psychic, or to make sure that the resolution is final and doesn't unravel. The problem, of course, is that we saw in the Me Too movement is that these confidentiality provisions have also been used to cover up misconduct or as a way for the employers to really avoid fixing the problem in their internal systems. And maybe preventing other people from finding out about it and also bringing a follow-on lawsuit. So how do you try to regulate it? This is how states have tried to regulate it, and I think mostly have not really been successful at addressing the problem. Okay, so let's just first talk about these contracts. So these are the contracts that workers sign at the start of their job that says, I will keep all of the company's information confidential. Mostly these provisions have a legitimate use to protect trade secrets. One of the problems, however, is that employees might misunderstand the contract and think that it covers unlawful conduct and might mistakenly think that they can't report unlawful conduct to the government or talk about unlawful conduct on social media, even though actually they're allowed under the law. So one of the things the courts have said is you can't enter into a contract that says you have to keep this type of information secret as a condition of your employment. That actually is actually a pretty effective way to regulate this particular problem. because the way that employers can address it is they can just have their usual contract with a little exception in it that says, keep our trade secrets confidential. However, of course, you are allowed to report unlawful conduct, including harassment. This is pretty effective because the employer still can protect its trade secrets, but they're also informing employees about their rights when it comes to speaking about unlawful conduct. So this is actually one of the rare examples where this kind of regulation can work. However, when we talk about settlement agreements, it actually becomes extremely difficult to regulate in a way that would address the sort of misuse of confidentiality agreements. So one of the ways that states have tried to regulate settlement agreements that are secret is they say, you may not have a confidentiality provision for any claims involving harassment or sexual assault, for example. One of the problems, however, is that states have included exceptions in that for various situations that they think are legitimate. So they might have an exception that says, well, if the victim requests secrecy, you should provide secrecy. Or maybe this requirement only applies if the case has only been filed in court, but it doesn't apply if you settle it before you go to court. Or maybe this doesn't apply if both parties agree to keep it secret. You know, that all makes sense. It makes sense to include exceptions. But of course, if you're a bad actor and you want to exploit this, you can find ways around this. So you can decide and this is what Harvey Weinstein already did. You just settle, if you have this particular restriction, you just settle the dispute really early on before it goes to court, then you can still have secrecy. Or you just tell the other side, okay, well, we want it to be mutual. Or you tell the other side, we need you to request it. If confidentiality is important to us, but you, the victim's lawyer, have to request it, and then we will make a deal with you. So like, these don't really do a very good job or aren't completely effective at addressing the misuse of confidentiality provisions because, it's actually really hard to preserve these legitimate uses while also getting rid of these. It's just impossible to draft a statute that is exactly tailored for the bad conduct. The other way that states have sometimes tried to address this problem is to include various procedural requirements if you want secrecy. So they'll say, well, if you want to have a secrecy provision, you need to be represented by a lawyer and you need to inform people of their rights. And then after a period of time has expired, the secrecy will go into effect. That's a common way to protect employee rights in the United States. And that is a good thing to have. But of course, if you're a very bad actor, you can find a way around it. You just comply with the procedural requirements and then you get secrecy. And, in fact, any of these particular requirements probably would have worked in the Bill O'Reilly case. So, I think courts or states are really stuck with the fact that they're probably not going to be able to regulate this in the exact way they want because there are too many competing interests that they're trying to satisfy in regulating this problem. Okay, so lastly, I wanted to talk about dispute systems designed for employers. This is just a cut and paste from the earlier reasons why there are problems in the way employers design their systems. It's because of the way the legal rules are structured that give them a lot of credit for having a bad system, that don't force them to disclose information to the workers, that leave some workers behind. And the fact that these cases are just not very valuable as a legal matter. So if you want to have like a robust change to employer practices, you might have to go back and fix these systemic problems that are contributing to the bad dispute systems design. So here are some of the ways you could design a better internal system. One would be to include more groups when you design the policy and when you design the system. So instead of just leaving it to the lawyers and to HR to draft the policy and system, have the employees be part of the process and ask them, what kind of system would work for you? What do you think would be fair? What kind of information would you need to know to have confidence in the process, and involve them in designing it? And also to include more information in your policy so employees know what to expect.
In practical terms, how do you call the employees to show them their...
I mean, I think it's the usual problem of like figuring out who are the right stakeholders and who would, if you don't have a union, who represents employees. But, you know, it's actually pretty common for American employers to have task force for things and committees for things, and for people to, you know, nominate the employees or informally discuss like which employees would be best represented for them.
Focus groups.
You know, like a focus group or a committee or a task force. Those have been pretty effective in American context. So something like that. Or, you know, listening sessions where they invite employees to tell their stories and ask the employees what they want, where a bigger group of employees can express their opinions. And then giving employees more process choices other than just issuing a formal complaint, so that they don't have to be brought into a really formal process if they don't want one. And also to share more information with employees at the end of the process, so even if they don't like the outcome they received, at least they understand what it was and they feel like they were treated fairly. And if you want more information on that, here's the law review article I wrote. It doesn't include everything that I talked about today, but it includes some of these topics. So that's all. I'm ready for questions.
Any questions at all? Just try to summarize some my the most important topics, at least under the way I reacted to your lectures. Basically, I think the first idea is that, and correct if I'm not accurate. The first idea is that if you don't have a friendly and accessible judiciary system, it's very difficult to have a ADR system as well effective, friendly and accessible. I think it's the first thing we have to try to take into account. The second thing that when you teach people to negotiate, you try to improve skills, but you also have to a certain extent, try to bring them in a continuous qualification and continuous process of teaching and improving their skills. I mean, it's not something to be done once and you go back to your resume. Probably this could be a continuous process of training and retraining and supervising, submitting to supervising, to external supervision. I'd say also that to a certain extent, if you don't have a friendly and efficient ADR system, the ADR system could and can effectively, in reality, block the access to justice. It's an additional wall, it's additional hands to avoid the path to judicial protection, judicial outcome. I would also be aware about the importance of thinking about not only an ideal, a previous model of design a system, but I think if you think about designing the system, the ADR system, or any other prevailing or solving dispute system, you have to try to identify, first of all, what you want to achieve with this, to diagnose your problems, to try to identify the problems that you really intend to address, and try to identify also the goals, the purpose that you want to achieve. I mean, not only diagnosing, but also trying to reveal the goals and the final purpose of your system. In other words, it's impossible to evaluate the results if you don't have clearly defined previously your goals, your purposes. I would say you also have to take into account the possible unintended consequences, the unintended byproducts. I was talking to this. I don't know if here the story of the small claim courts in Brazil. And correct me, please, Judge Bruno, if I'm wrong. One of the main purposes to provide a friendly but especially a fast-track civil procedure to provide fastly decision from the courts. Well, the system sort of was very successful, but probably on account of this succeeding the results, it was attractive to more and more suits being filed. So I don't know exactly when, at least in the state courts, the small claim courts became even worse than the original, the regular civil procedure system, because, well, if the decision in the civil procedure in the ordinary courts took about 3 years, some of them are just close to it in the small claim, and well, you have to be prepared to face the unintended consequences, the unintended byproducts of your system. And I think, well, basically, you have to be very aware about what is system all about. I mean, what is a systemic way to think about justice? What should be a different way, a different perspective to address judicial policies? I would say justice policy, not judicial one. Justice policy altogether. Justice, judicial, and ADR policies. And well, this is just brainstorming, trying to review some of the many issues that as I said, my personal reaction to your beautiful, to your wonderful, and very surprising approach, because we are, to a certain extent, still in a moment of being very naive and very well open-minded to improve ADRs, but we're not exactly very advised about how risky, how dangerous, and how should we be careful to avoid some mistakes. And this is the reason why, when we talk with people that come from countries that have different and more important, more developed experience, can be helpful for us to go through the well, different possibilities and to be more careful and successful. What about you?
Well, good morning for everyone. Thank you very much, Professor Liz. I was not able to come to all your lectures, but I have at least the same impression of Professor Freitas. I think now, at least in Brazil, speaking from the judiciary view, from the court view, or even from my personal view, we notice that justice, to use Professor Galanter's expression, are in many doors, but we are a little bit naive because we are still thinking that the ADR doors are better for every conflict, or is the solution, or if you have we frequently use an image about a traffic jam, as the courts are congested. There's traffic jam in the courts. Now we have lots of other ways to reach justice, but sometimes we are really not criticizing these other paths and these other ways, and we are just saying that it's better because it's cheaper, because it is faster, and we sometimes forget to ask, is that justice the type of justice that we are intending to reach or not? And so I think the overview of the lectures that I was able to see from you. It was very nice to see that you have this, we bring us this critical view in order for us not only to reflect about, but also to try to change some of our political options. Thank you very much.
It's, with that, a critical approach, but critical but based on evidence. So it's scientific criticism. This is very different from just prejudice and just trying to be attached with any product or any ideological bias, or at least strictly ideological bias. I separated some pictures to some. We are facing here something very similar to the Me Too reaction, and I was trying to figure out what sort of relation, what sort of connection with the reaction of the Me Too before the Trump administration, whether that could be to a certain extent, to any extent, connected to the reactions of the women movements, the women riots in the first days of Mr. Bolsonaro's administration. I was wondering if what should be the prevailing, or at least the most probable reasons why far right administrations put an administration challenges some of the civil rights and some of the human rights regions of protections that will feel very, very worried about it, and we feel that we have to sort of show some reaction publicly. And but what is interesting in Professor Lee's lecture is that we could have a very interesting evidence of how the political and social activism could bypass the blocking process of self alimentation, self-feeding of the process, vicious alimentation of the process that, like she told us, between 80 hours in the judicial system, how this is very interesting, and it's a kind of way to make us a bit more modest about our expectations regarding changing legal provisions. Well, we are legal protectionists, legal students, legal researchers, legal faculties, and we are basically ordinarily very we put a lot of expectations about legal provisions, and it's a kind of an opportunity to revisit our optimistic standpoint about it. Also, I would remark the importance of reviewing, and I at least for me, I will check each one of the items of yesterday's lecture about how to teach and how to improve skills. I think it was wonderful because it goes far beyond the traditional, the boil something, the way to
boilerplate.
Yes, in teaching negotiators, mediators, what we call conciliators, and stuff like that. So, any other final remarks? Any other comments? Any other questions? You're yourself welcome to do it, sorry. No, for her.
Don't have the time or university, all, and eventually that knowledge or from reading a text And class. Just that.
Okay, you're very welcome. Man.
Thank you very much.
And we have so interesting way to offer a bibliographic landscape in the first class, in the first lecture of this course. That was fantastic. I was paying attention. Well, I will incorporate this way too in my lectures from our side. Celia, any other comments?
Oh, I wanted to say, for me, I feel the same way in terms of, for me, it is a great opportunity to hear from all of your experience and learn about the Brazilian situation and how the Brazilian cultural approach and the Brazilian judicial system influences the way your system is designed. And I think that the Brazilian system has many strengths, both institutional and cultural, that I think are very instructive and very interesting for the American system. So I feel that being here is a great opportunity for me to hear from you live about your experiences of your system. And so for me, it has been very great as well.
Celia, any final remark?
We went to the forest 2 days ago, and I put inside Indian prayer house with no lights, with a situation and a conflict, not conflict, but she was nice and was very well.
Yes.
We went there because we had a situation
Like a period of dialogue. Some final comment?
It was very nice to there. Thank you a lot. I learned a lot.
Thank you.
The other one? Okay. Thank you so much, Liz. I'm very proud.
Thank
very
you.
proud
Thank
to
you.
have here.
Thank you. Yes, sure, yes. Sure. Yep, hold on just a sec.
Yeah, it's challenging. Sometimes we have some trouble, but it's part of a. Yeah.
Here's your clicker.
It was a gift from Henrique.
Oh,
Yeah, Henrique gave
nice.
me. I should told him that it's a gift from. Yeah, really very useful. Sometimes it makes a lot of difference. Yeah. If you stick with them. Yeah. A couple of minutes more for pictures, if you don't mind.